Hi, I'm Sandy Thomson, the host of this show, which is called Life Ahead. But the real star of the show is sitting here with me on the set, and that is Bryan Nugen. He is an attorney specializing in elder law. If you watch Life Ahead regularly, you've seen him many, many times here on our set. PBS sponsors this show, obviously, every Wednesday night at 7:30. We have different topics, different guests. But again, some of the regulars, like Bryan, bring a nice element here because our viewers get to know them. And I hope that you feel comfortable with Bryan, because this is really your show and I want you to ask him questions. The phone number's on the bottom of the screen there, and you can give us a call here through the show at that number, and Bryan will answer your questions. Won't you, Bryan? You'll do that?
Well, certainly, I sure will. Thank you.
And Bryan loves it if you stay on the phone and talk to us live, because that way if he has a question back to you, you're right there on the phone. But if you're not comfortable doing that, that's okay. We do have a phone operator in the control room that will take your question and type it up and send it out to me here on the teleprompter, and I'll ask you for them.
Yes, of course.
Okay.
Please.
All right. Bryan is going to be talking tonight about probate, specifically, if we're going to narrow law down here a little bit. But if people have other legal questions about elder law, please give us a call here. The last two times you've been on, we've talked about terms, like legal terms.
Yes, that's right. A good memory. We spoke about different terms and things that the audience may be hearing me speak about, and questions you may be asking me about. And I want to make sure that everybody in the audience understood some of those basic terms. Well, one of those being probate, but some other issues as well. So I think it's great for the audience that's listening to be educated about elder law, estate planning, etc. And so hopefully the terms that we defined over the last few programs will help them as they're looking for advice and information in relationship to elder law and estate planning for their own personal needs.
And I always learn something new from you. In fact, I think it was the last time you were on, you kept talking about instruments, and I'm thinking, that's right. This is not a musical show. And then he explained that
it's a you might say a document. Yeah, that's right. So
legally you would call that paperwork
document, written instrument. That's right.
Instruments. Well,
so they're synonymous.
You know, when I learn something like that new from you, I try to work it into conversations with other people and act like I knew what I was talking about. Well, okay, let's talk about probate. And again, give us a call here, 969-2720, with your questions. All right, let's start with definitions. What is probate?
So probate is the process whereby when someone passes away, we take their will, their last will and testament, and we go to court. And that will is then filed with the court. And once that's filed and the court issues something called letters testamentary if we have a will, and appoint someone to serve as a personal representative. And that personal representative then is able to get into the assets of the deceased party, is able to determine what debts are out there, so gather those assets, figure out what debts exist, and then there's a process whereby we're satisfying those debts that are appropriately paid and distributing assets in keeping with the individual's estate planning, assuming they had a will. If they didn't have a will, we use something called intestate succession. But part of that,
you have to define that. I'm not sure what that intestate.
Thank you. So if someone passes and they didn't prepare a will, they didn't take the suggestions I'm making here on PBS to reach out to their attorney and have a will prepared. If you pass without a will, you have something called intestate succession, where the state in which you're living has a code site that determines where your money goes based upon if you're married, not married, children, not children. But then probate, so back to that point, once that we open an estate, there's a process whereby we're filing in the newspaper and letting the world know that this individual has passed away, and if you believe that they owed you money or there's an outstanding debt that's to be paid, we're going to advertise in the newspaper here in Indiana. It's a period of 90 days where folks have an opportunity to file a claim in the estate. And then, depending upon whether or not the estate is supervised or unsupervised, supervised means the court is approving everything before the actions have taken place or may take place. Unsupervised is where We don't need to necessarily consult the court before every step is taken. That doesn't mean the court isn't aware of what's going on. There's a process whereby we're reporting to the court as the probate matter is proceeding, especially at the beginning and at the very end of that probate matter. Oftentimes people will ask, if you're in the probate process, how long does that take? Well, it could take as short as I suppose technically 3 months. Unlikely it would be accomplished in 3 months, but I'm seeing maybe a year, give or take, a little more, a little less. Sometimes if it's more a complicated estate or if there's litigation in the estate, we may drag on beyond the year. And of course, there's expense involved in that. You would be providing payment for, the estate would be providing payment for the attorney that's representing the estate, the personal representative or representatives in the estate. They would also be entitled to have some type of a remuneration for the work that they've performed.
Okay, several follow-up questions here.
Sure.
The personal representative, or often just called PR.
Executor.
The PR.
PR, personal representative, executor,
okay.
All the same.
That's something that while you're still alive, I mean, if you plan ahead and you're doing a will or a living will or taking care of a lot of documents and naming your power of attorney and your healthcare representative that takes care of you physically and financially while you're still alive. But once you pass away, then it's the personal representative who handles the finances.
You've got it.
Do you name them in the will?
Yes. So if you have someone that you trust or an entity like a trust department that you may appoint, if you have somebody that you have confidence in that would have the wherewithal, the time, the acumen to make sure things are handled in a timely manner, in your will, you would appoint someone to serve as your personal representative or executor, same thing. If you haven't appointed a personal representative, you haven't appointed an executor, you didn't do that last will and testament, in that instance, and a person that would be appropriately appointed who normally has some type of an interest in the estate, the court would appoint them to serve on your behalf. So it could be a family member that would serve. It could be somebody actually that believes they're owed money and they don't see an estate being opened. They could force the estate to be opened and request that they be appointed personal representative. There is a code in every state that indicates who's kind of a preferred person to be serving as personal representative or executor if you didn't take that initiative during your lifetime to appoint someone to serve on your behalf.
So then the probate judge would look at bios or whatever of the people that are recommended or on that list? Or how do they decide which persons they're going to choose?
So there's a petition that's filed, and when
by whom?
By whoever wants to serve as a personal representative.
Okay, all right.
So they would prepare a petition, and they would request the court, please appoint me to serve as personal representative. And what's also important to know is that that petition needs to be served on other interested parties. So it could be other folks in the family, it could be other beneficiaries that you've designated within your last will and testament, or potential beneficiaries through intestate succession. They would receive a notice of that, and they have the opportunity to say, yes, this person is appropriate to serve, or no, I object. And then they would have the responsibility to indicate why it is that they object. And the court then would look at those objections, look at the petition, and make a determination as to whether or not that person should be appointed. If they are living outside of the state of Indiana, they would need to serve with a resident of the state of Indiana or post a bond to be able to serve. And the notion of the bond, if you're a non-resident, I'm saying Indiana, it could be other states, if you're a non-resident of that state, the purpose of that bond is that you couldn't abscond with estate funds. So I couldn't run away with cash. I couldn't run away with personal property. I couldn't run away with money from a bank account, etc. So a bond would be posted that's approved by the court. The court determines is it an appropriate amount for the assets in that estate that need to be bonded. And then you post a bond, pay for that bond, and then you could serve even if you weren't a resident of Indiana.
Okay, all right, that clears that up. Mike has just called in. Hi, Mike, and thank you so much for watching us here on Life Ahead. What is your question tonight for Bryan?
Okay. Well, I first of all, I love your program. It's very informative.
Thank you so much.
I also like Brian's suit. He's looking fine there.
I just told him that right before the show.
I debated to wear this or not, but it's a bright summer day, so.
I need to go shop where he shops. My question is, my wife and I lived in Indianapolis for about 35 years, and about 20 years ago, we had our estate plan done by a local attorney firm there. Since then, we now live in Fort Wayne. We also have a condo in Florida.
Great.
I'm wanting to update our estate plan. And I'm wondering whether I need to go back to the Indianapolis law firm or whether I can come to Bryan and have it updated here.
Okay, all right. So he doesn't live in Indianapolis. He's very lucky. He has a condo in Florida.
Yeah. So I see a couple of things. The first thing that I see is that, of course, the attorney that you're working with should be able to review that estate plan that was in place. So if you had one prepared in Indianapolis and you needed to have a local attorney review it, they would do so.
Yeah, he doesn't have to go back to Indianapolis.
Doesn't need to go back to Indy. What I would say, though, is I would be surprised if you wanted to change a will, if the attorney that you're working with would be willing to write a codicil or an attachment to the will that someone else has prepared. So sometimes an attorney will be requested, I just need to make a little change to this will. I want to use that original will and make a little change. I don't find it very common that an attorney will say, I'm going to add on to somebody else's work. Most likely, if you're wanting to make a change to it, assuming it needs to be changed, it may not need to be changed. I've reviewed estate plans, other attorneys have reviewed estate plans, and it's appropriate. So no change needs to be made, and you should feel good about that. But if there is a change that you want to make, the attorney says, is this still what you want to do? Do you want to remember this person, that person, etc.? You say, no, I want to make a change. The attorney most likely will want to rewrite your estate plan so that they're confident in what it says and it's their language and so forth. But you brought up another interesting point in regard to Florida. So what you need to know is that if you own property in more than one state and you pass, and you don't use a beneficiary designation deed, or you don't use a trust or something like that, you would need to go through probate in both states. You'd have to go through probate in Indiana, pay for that expense and that length of time, and go through probate in the second state, Florida in this instance. So Mike, if you have a condo in Florida and you have property in Indiana, you should seriously consider using maybe something like a trust that allows you to avoid probate, frankly, in both Indiana and in Florida. There are deeds that you can do both in Indiana and Florida. In Florida, they're called ladybird deeds. In Indiana, they're called transfer on death deeds. But you could use those. We don't always use those. I am a little cautious to recommend that, yes, we can skip probate by using those deeds. But I like to give folks the example. If you were, let's say you have 3 children, and you convey that property to them at the time of your passing using one of those types of deeds I've just explained. Now your children own that property together. So if one says I want to sell, 2 say I don't want to sell, we've got some conflict there. Also, when those deeds are written, if you're saying if one of my children passes and their interest goes down to their children, now you have 2 kids that are owning property with their nieces and nephews. So if nieces and nephews don't have any money, but they want to go down and party in Florida, you're creating a bit of a situation for the other 2 children. So while those beneficiary designation deeds can be very useful in certain circumstances, and you will find attorneys using them in certain circumstances, it isn't a blanket way of avoiding probate that we should use every single time. You should explore the pros and cons of those very closely. But so to swing back to your question, Mike, I've gone a little off track. To swing back to your question, yes, an attorney licensed in Indiana would be able to review your estate plan by an attorney that prepared that in Indianapolis, no issue whatsoever.
Okay, all right, good explanation. And Mike, I hope that's helped you. Certainly a lot of information there because you have that unique situation, and life changes in 20 years. Who knows? And maybe he's probably bought the condo in the last 20 years. Yeah. Maybe you have a different family now. A lot of people do have those kind of changes, blended families, or more children or grandchildren, that kind of thing. Okay, all right, we're going to keep talking here, and we're going to get Jim, your call here in just a few minutes. Meanwhile, we talked about the personal representative. Let's see, what else was I going to ask about probate? If you've named somebody as your personal representative, what if you change your mind later, or you start to figure out that personal representative is taking advantage of situations and maybe not as honest as you thought they were? Can you change?
Well, during your lifetime, if during your lifetime, can you change your estate plan at any point? Yes, you may. No, so long as you're competent and understand what you're doing, and there's no issue with your changing your estate plan at any point. If you're looking to change the appointment of the personal representative after the estate has been opened, after that executor has been appointed, that PR has been appointed by the court, in that instance, someone is going to have to petition the court and ask for them to be removed and explain to the court why it is that they should be removed. Maybe they're not gathering all of those assets appropriately. Maybe they're delaying the entire process. Maybe they're challenging whether or not you should receive the funds, and you believe you should be receiving the funds, and there's no issue there. In those instances, yes, an interested party could petition the court and with reason could say, I want this individual to be removed. But it wouldn't just be because I don't like my sister, I don't like my brother, I never like my aunt, she's cheating me. If the aunt can demonstrate that she's not cheating you, she's doing everything appropriately, and there's a reason for the delay, then the court will most likely say, nope, I'm going to leave in place this personal representative that the deceased originally appointed. Courts generally want to recognize what the deceased party was wanting in their estate plan. They want to respect the individual that you appointed. But if that person goes sideways, right, if that person is making some very poor decisions or taking an inordinately long period of time within which to settle that estate, the court may very well set them aside and appoint someone else.
Okay.
Yep.
All right. See, it's just so complicated. But thank goodness there are people that do know the answers. Thank you for those answers, Bryan. Jim needs some counsel here as well, Bryan. Jim says, can you use the Miller Trust to make the power of attorney in Medicaid in calculating the pension? I'm not sure what the Miller Trust is here.
Okay, so let's talk about first the Miller Trust. So the Miller Trust is used when we're applying for Medicaid if your income is over a certain threshold. If your income is over a certain threshold, you're not eligible for Medicaid. So Indiana, like other states, not every state, but Indiana, says we can use something called a qualified income trust, also called a Miller Trust. Those trusts, your income, Social Security, pension, whatever it may be, comes into your checking account. It goes from your checking account into this Miller Trust or Qualified Income Trust checking account. And from there, we use those monies to pay for your medical care. And when you're using that Miller Trust, that Qualified Income Trust, Medicaid says, okay, we're going to ignore the fact that your income is too high. And then you'll be able to get those Medicaid benefits. Did I say Medicare? I feel like I said Medicare. I intended to say Medicaid.
I know, it's so confusing.
So completely different programs.
Right.
So Medicaid will ignore your income if it really is too high when you use those Miller Trusts. The consequence, it's not a consequence. The idea is that if money was going into that Miller Trust during your lifetime when you were receiving Medicaid benefits and you pass away and there's still money left in that Miller Trust, the money that's left over is then reimbursed to the state to pay them for any services that they provided on your behalf through Medicaid. So if you have $2,000 in your Miller Trust at the time of your passing and Medicaid used $1,000 for your care, you owe the state $1,000. Then the remaining $1,000 can go to whomever it is that that you've designated as the beneficiary of that Miller Trust. But if there's $2,000 in your Miller Trust at the time that you died and the state paid $50,000 for your care, then all $2,000 goes to the state, and the remaining amount, assuming there's no other estate to gather the money from to reimburse the state, it doesn't have to be repaid. But going on with your question, Jim, to make the power of attorney, Medicaid is calculating the pension. I'm not sure that I understand that question. Pension, if you're asking, we don't shelter your income, but we would move your income from your checking account where it initially lands into that Miller Trust, yes. Income goes first into your checking account, savings account, wherever you normally collect it. It comes out of that, it pours over into that Miller Trust, qualified income trust, and then we use that money to satisfy a portion of your medical expenses. And if money remains there when you have passed, it goes back to the state to reimburse them for money they've spent on your behalf. I hope I've answered your question, Jim.
Okay, if not, Jim, call us back
so
and
let me
we'll
know,
work on it again. Okay, Bryan, here's a question. We've talked a little bit about, and you mentioned the transfer on death.
Yes.
I know the legal abbreviation for this, TOD.
TOD.
Yeah, TOD. Okay, so transfer on death or beneficiaries, what are the pros and cons of those?
So, let's say not only with real estate, but if we have a checking account, a savings account, a brokerage account, an IRA, you can designate beneficiaries on any of those accounts. And it can work beautifully, and it does work beautifully in a very, for the most part. But in your estate planning, if you're saying, I want money to go to my children, but I don't want my kids to receive the money until they're maybe age 25, age 35, or beyond, or I only want the money to be used for certain purposes, or I want to use the money for my children during their lifetime, and then I want it to go to my grandchildren. So any of those bells and whistles that you want to add on, those special controls that you want to add on, you can't accomplish those with a beneficiary designation alone. So if I'm saying, I want my 401k at work to go to my spouse if my spouse is living. If my spouse is deceased, it then goes to my children, and my children are minors. That money would be distributed for the benefit of your children when they're minors, and then at 18, they get the money. So there are times I like to use transfer on death deeds. I like to have accounts with a transfer on death beneficiary designation. So TOD, BOD, POD, payable on death, beneficiary designation, yes. Those are oftentimes used. But you need to make sure you understand that if you have a will or you have a trust, and you've also done a TOD, POD, beneficiary designation, it skips your will. It skips your trust.
It takes precedence.
It takes precedence. So you have to be very careful about when you use those and how you use them, and make sure that you really are accomplishing what you want to get accomplished. I especially like those if we have a single beneficiary in the estate, and that beneficiary is a mature person. So we're not concerned about their getting the money early. And maybe if that person is predeceased, it goes to their children, and their children are of an age where I'm not so worried about them getting it. I'm very comfortable using that beneficiary designation, transfer on death designation, but you just have to be careful about it and make sure you're aware of the pros and cons on that.
What is the difference between transfer on death and payable on death, the TOD
synonymous.
And the POD?
So initially tonight we talked about deeds. So the deeds in Indiana are called transfer on death deeds.
Okay.
But sometimes if you're at a bank, the bank will say, this is a TOD account, POD account, beneficiary designation account. For in those instances, at a bank, at a brokerage house, with a financial advisor, TOD, POD, beneficiary designation, all the same thing. But for deeds in Indiana, they're called transfer on death deeds. They're not called beneficiary designation deeds. They're not called payable on death deeds. They're called transfer on death deeds.
Okay. And Jim called back, by the way, Bryan.
How would you obtain access to the Miller Trust?
Yeah, he wanted to know how to obtain access to a Miller Trust.
So, of course, you could seek counsel. You could speak to an attorney to do that. Aging and Home Services may be able to provide that to you. Aging and In-Home Services may be able to provide that for you as well. Am aware of some local banks that have very basic Miller Trusts that they've used. And understand this is coming from an attorney, so my advice to you would be seek out an attorney to have it prepared and understand how it works, fully understand how you can designate beneficiaries in that Miller Trust. So, but how do you access them? As I say, some local banks have them. I've seen people, have come through my office where they sign them at a local bank. I have also seen nursing homes that have used those for some of their residents. I'm always careful about that. I am cautious about saying to somebody, find a form online.
I know.
I'm very sensitive to that. That can create problems for you, and it's not what you know, sometimes it's what you don't know.
Which is why most attorneys, at least that I've talked to, have said, don't do a will online.
No.
Although you hear it advertised, it could create problems.
You're saving a few dollars now, but it can cost you a lot in the future. So I would really encourage you to use appropriate counsel. Seek out somebody that you have confidence in and that it's making sense to you when you're speaking with them, to get those documents in place and make sure that they're properly aligned with what you want to get accomplished. Yep.
Brian, our time has, as always, has gone way too fast. Brian will be back again next month, and if you have questions, watch for Brian. He'll be coming up here in a couple of weeks. And we appreciate all of your questions tonight. And Brian, I appreciate your answers for our viewers here. We'll be back next Wednesday at 7:30 with a new topic and new guests. Meanwhile, tonight, just stay happy and stay healthy and safe. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.